Good morning. This is the matter of Green versus Green. We're here, I'm sorry, present in the virtual courtroom is the defendant, Ms. Green, her attorney, Ms. Camfield Kuiper, and attorney Jason Van Elderen here on behalf of the plaintiff. We are here on the plaintiff, Mr. Green's motion regarding the minor child's daycare. I've read both the motion and response. Mr. Van Elderen, is there anything else you'd like to say other than what you've already said in your motion?
Yeah, I think this isn't a matter of, we're not asking the court to, and we're not saying that, grandma can't ever watch the kid. That's not really the point. The reality is that, at this point, the parties have week on, week off. And my client, or they're doing a 50-50 thing. So my client has, some daycare needs that he has to work around his schedule. It's not, this whole thing started when the defendant went down to Indiana and wouldn't come back.
I know all of that.
Yeah. So I think the parties need to be able to coordinate daycare. I don't think it's fair to force my client to use the grandma as his daycare provider. And I think that if a daycare provider is needed, that's going to cost money. That cost needs to be allocated across the parties.
Ms. Camfield Kuiper.
Good morning, Your Honor. Well, first, I don't know why the plaintiff isn't here if it's his own motion. I would ask that the court consider that and potentially dismiss the matter because he hasn't seen it important enough to show up himself. So secondly, Mr. Van Elderen and myself have agreed to and stipulated to send this matter to the friend of the court for custody, parenting time, and child support calculations, which of course would include any child care that was put into place, if any. But our response clearly indicates that a daycare setting other than the home that the child has been seen in and cared for by his grandmother over the course of his young life is a risk to him. I'm not looking just at the convenience of the plaintiff here, Your Honor. My client is looking at the safety of her child. And for the time that he was in the Apple Tree Center, he was sick for 3/4 of that time because he caught a virus or something at the daycare. He is susceptible to it because of his condition, and that places him at fragile medical risk due to that. He is more susceptible, his immune system is decreased, and so having him in a daycare setting, as opposed to a cleaner, monitored, less other child contact home, is definitely a risk to the child and not in the best interests of the child. This entirely focuses on the child, Your Honor. My client's very concerned for him being in a child care setting where he would be exposed to not only the children, but the adults dropping those children off, the teachers. This is just fraught with exposure to germs and bacteria that could seriously affect the health of this child. So we're asking that the court deny the motion at this time, allow this to go to the friend of the court, let everything be determined there, and let the parties work out what they're going to do for daycare if the plaintiff doesn't wish to use the maternal grandmother. But I think at this point, it's appropriate to deny it. Would ask the court do the same.
Mr. Van Elderen.
Your Honor, I think that we haven't heard from any medical professionals that would state that this child is at an extensively increased risk. I think that, any children in daycare, that's part of what happens. You're exposed to additional children and you're exposed to everything. But the child's going to have to go through that at some point with school and that sort of thing anyway. it's not like this, this can't be mitigated at all. They're not having, this isn't, the problem is that the parties aren't really having, I think rational discussions about this. It's just, well, here, my mom has moved up here. She's going to watch the kid. It was, at first they were talking about looking into different daycares. And then she stopped doing that and hasn't responded to any of my clients' inquiries about it. And they're looking into, he's looking into some smaller daycares, some, that are not going to be as much of a risk. and ones that may be more flexible in terms of his schedule. So, and you know, I think the child needs, it's in the best interest of the child to have socialization and that sort of thing. Given what happened and what transpired at the beginning of this case, I don't think that it's appropriate that, you know, I think it's a little odd that grandma's moving up here. I mean, this just seems like another way that, you know, the defendant is trying to control the situation and drive a wedge between the child and dad. I mean, this grandma does not get along with my client.
Again, I know all of that. I read
so-
all that. It was in your motion. So, all right. Well, at this point, this matter is being referred to the front of the court for a closer look. However, I think this court's position, as well as the case law, supports that daycare is to be determined by the party whose time it is, if they need daycare, and that both parties are to share in the expense. Given that what it appears this child's needs are, I will indicate that each parent is to provide their own daycare, that the plaintiff is to obtain daycare that takes into consideration this child's needs with his medical condition, and that confirmation and verification of exactly what, from a physician, of exactly what kind of environment he needs to be provided and shared, so that choice can be made. But both parties are going to need to share the expense by virtue of the child support order. So.
Thank you, Your Honor.
All right.
Thank you, Jim.
I'll prepare the order.
Present in the virtual courtroom, we have
Thank you.
both parties, along with Ms. Brandstorfer on behalf of the defendant, Ms. Matthews. We are here on the plaintiff's motion to enforce and clarify the judgment. Mr. Matthews, I have read your motion rather thoroughly. Is there anything else you'd like to say?
I just want to respond to some of the things that were mentioned in the response from Ms. Brandsdorfer, if that's okay.
Okay, that's fine.
So in short, we have, you know, I'm just trying to get this tax thing figured out. In looking at the amended judgment of divorce from June 22, it talks about both parties being involved. The understanding was that would include both plaintiff, or me, and Michelle. And it was understood that we were trying to get that clarified, and then we would split a benefit or a loss equally. And so that was my perspective there. And then as far as claiming the kids, I claim my son every other year. It seemed that the pattern was there with the way that Michelle was claiming the kid, or I'm not sure if I should refer to her as defendant. I'm not sure what's proper there, but I'm just talking normal here. I'm not a lawyer.
And that's fine. That's fine. That's fine. As
Okay.
long as the record's clear as to who you're talking about, that's all that matters. And it's respectful.
So I appreciate that. I'm just trying to clarify this issue and get this resolved so that we can move forward, finishing out with the judgment of divorce. So that's really the part there. I don't think the minutia needs to get into. I mean, obviously you have all the things that I already mentioned in my motion. And as far as the orthodontic care and so on, my son sees Williams Orthodontics, Piper's seen Williams Orthodontics. It's never been my recommendation to see them. The dentist, Van Haren, has both of them. Katie and Ann both recommended Williams Orthodontics. They recommend a number of orthodontists, true, but I was hoping to keep consistency for Maeve with Graham, and not that Graham's a party here, but with Piper as well. So that was another part of that. And as far as on the appointments, I think it's really important that a father be a participant in any kind of care, especially relating to any concerns related to mental health. Obviously, in my profession, we work with mental health all the time, and it is a key part of stability. And for the the father of children to be ignored when it comes to either counseling or when it comes to testing doesn't seem appropriate. And Michelle hasn't notified me, even when the girls started to see the counselor. She neither informed me nor gave me any information about anything related to that. Nor did the counselor reach out until I reached out to her. And then we were able to have a meeting with Piper and Maeve and the counselor, myself, and Piper and Maeve had a discussion, and subsequent to that, then Piper no longer was in need of seeing anybody. And after that, then it was decided for Michelle, and I'm not sure what other party might have agreed, maybe the counselor, that Maeve needed ADH counseling or ADH testing. And I was opposed to that only because I didn't feel like she had the symptoms. But that being said, the observations I've had with having her at my house should be pertinent to that understanding of whether she is ADHD or not. The results were very clear. She is not ADHD. She's just unbelievably smart, which, great for Maeve. But it doesn't mean that at any time a father should be excluded from those kinds of things. So, and I'm only going into that because it was mentioned per Ms. Brandsdorfer that somehow I'm trying to malign appointments, and that's not the case at all. I'm trying to be supportive and trying to do all the things that I can in that regard. Also, it was mentioned that there were insurance issues going on. I've had the same insurance since 2021. I've never made any changes. They've always been insured. I've never tried to hide information. It's the same insurance. So I'm not sure where that's coming from. Michelle had applied for Medicaid. The girls have Medicaid. I don't have any of that information. So I'm not sure why that's being mentioned here in any way at all. So that's why I was requesting the things that I put in my brief. I'm just asking that I get informed of appointments. I'm asking that we figure out the tax things, and also that there's consistency for the girls with the orthodontics.
Ms. Brandsdorfer.
You did get our response, is that correct?
Yes, I did, and I've read it. I'm sorry, I should have led with that.
That's okay. I'm going to try not to be duplicative.
Thank you.
Mr. Matthews talks about what people understood at the time of the judgment as if this were a negotiated judgment. It was not. It was a judgment drafted by his attorney after trial based on Your Honor's opinion. Had Your Honor ruled that the cost of that tax preparation be split, I have no doubt that Mr. Pereira would have put that obligation in the judgment, because it would have benefited his client. That's not in there. You did not rule that she had to share in the costs of tax preparation. And I don't think it would be appropriate to amend the judgment now to impose that obligation on her. In terms of claiming the dependents, in the course of this motion, I discovered that Ms. Matthews did not appreciate that she was entitled to take both of them. She has only been taking one. And I don't know that there is any change of any sort of circumstance that would suggest that the decision of the court should be modified. But as I indicated in the response, if it is, we need to revisit child support because the calculations were based on her getting both dependency exemptions. With regard to all of the medical stuff, Mr. Matthews has always taken the position that he is behaving in the girl's best interest. But after trial, after hearing all the evidence, Your Honor recognized that what he actually does is interfere, both overtly and covertly, if he disagrees with what's going on. And Ms. Matthews would request that Your Honor not empower him to do that more by changing any of the terms of the judgment. Finally, with regard to insurance, I don't know if he's being deliberately obtuse or if this is somehow more nuanced than I think. All he has to do is tell Blue Cross that the children are also covered by Medicaid and they will have more insurance coverage. If he doesn't do that, if he continues to refuse to do that, then I think maybe the court should consider increasing the percentage of uninsured medical that he has to pay, because he is causing insurance healthcare costs to be uninsured when they otherwise could be insured.
Okay, thank you.
May I respond?
No,
Oh.
we need to get through this here.
Okay.
So I reviewed both the judgment, as I said, the plaintiff's motion to enforce and clarify, as well as the defendant's response. The judgment's crystal clear, as Ms. Brandsdorfer has stated. It was based on my opinion that was drafted after multiple days of trial. The defendant was granted sole legal custody for good reason. And there's absolutely no basis in the judgment for any of the things that the plaintiff is asking for at this time, nor has there been any change in circumstances pled. So I'm going to deny all of the requests. I will, and by the plaintiff, I will, and I also want to say that had Mr. Matthews, had you taken this to an attorney to clarify or to explain to you what it all meant, we wouldn't be here today, I don't think, because it's very clear and there's no reason to modify or clarify at this point. It is what it is. As far as the insurance issue, I will order that the plaintiff immediately inform Blue Cross Blue Shield that the children are covered by Medicaid. And if Ms. Matthews can provide, or Ms. Brandsdorfer can provide that Medicaid number, I don't know if they require that, but in case they do, provide Mr. Matthews with that number.
I've already called. I've already called Blue Cross. I don't know what more I could do.
Well, you're going to need to inform them and provide proof to Ms. Brandsdorfer that you've done that. All right.
Thank you, Your
In the
Honor.
virtual courtroom, we have both parties, as well as Mr. Shirley representing the defendant and I'm sorry, representing the yes, I got it right. representing the plaintiff and Mr. Glovic representing the defendant. We are here on the defendant's motion regarding parenting exchanges, a motion to prevent travel, and a motion for an order to show cause and request for attorney's fees. My understanding after discussing the matter in chambers with the attorneys is that several of the issues have been resolved by agreement, and I guess at this point I would ask for one of them to place that on the record.
Well, yeah,
Mr. Glovic.
Well, as the moving party, and yes, for the record, as discussed with opposing counsel in chambers, the way I see it, I mean, there are 4 issues here today, 2 of which are resolved. The first is the parenting time exchanges. It sounds like both parties are fine with the defendant mother participating in parenting time exchanges at this point. And then the parenting time adjustment as they agreed. It sounds like they agreed to that, so we just need that memorialized. And that would be, just to be clear, the Monday, Tuesday overnight during off weeks will instead, the defendant will instead have extended parenting time during her long weekends from Friday at 10 a.m. through the following Wednesday at 6 p.m. The 2 remaining issues are, first, a non-communication. We've expressed our position. I've read opposing counsel's answer in which they allege that no response is a no. I simply don't buy that. No response is no response, and no response is prohibited by this court's unambiguous directives. I don't think this court could be any
Mr.
more
Glovic,
clear.
I was just asking for the things that the parties had agreed to at this point.
Okay, perfect.
All right. Was there anything else?
Sure. Well, I can continue with the 2 remaining issues, but I've already stated what's been stipulated.
All right, Mr.
Already.
Shirley, is that the agreement?
Yeah, Mr. Greenway, I would like to inquire of Mr. Greenway, does the parenting time adjustment in terms of the exchange and the time frame, is that agreeable with you?
You're gonna need, okay,
Yes, that's fine.
okay.
All right.
Wonderful. All right, and now, Mr. Glovic, if you would proceed with the rest of the issues, please.
Of course, yes. And so we really just have two remaining issues. The first is the issue with communication. And, the argument that we receive, that I read in the answer is that no response is a no. And our position is that no response is no response. And no response is a violation of this court's unambiguous directives. I don't think this court could be any more clear. We've indicated several situations in which there's been no response. And this isn't a matter of failing to answer within a couple days. The standing order requires 48 hours, and that's because we do have what I observe to be a novel situation in which one party has legal custody. And so communication is key here. And so with that 48 hours, we're not looking at a couple of days late. We're looking at weeks or months late. And so we have a myriad of issues that are going completely unaddressed. And these are not non-issues. I mean, we have new challenges concerning the parenting time exchanges, which it sounds like there's a stipulation. And so we could have resolved that if we just had some communication. There's the issue.
I'm gonna stop you for a moment here.
Sure.
And ask Mr. Shirley, do you have any response on that issue?
Yes, yeah, Your Honor. As far as the My Family Wizard communications, if Mr. Greenway is remiss in not responding the word no instead of not responding at all, I will instruct him that that would be the appropriate action going forward, to just say no. A short and pointed answer is sufficient. I think the issue is that he, over the years, has become frustrated with overzealous communications that deviate from relevant issues. And that's the result of his failure to respond at all. But I can certainly direct him to make very direct and brief responses if that's what the court deems appropriate.
I think the order is very clear that there needs to be a response within 48 hours, and I would agree that no response is not compliant with the order.
All right. I don't want to just rag on this issue, but I do want to make it very clear that, I don't want to just encourage a simple no and dismissive behavior, because some of these things aren't just a matter of yes or no. So if there's a question, hey, do you have the first dentist appointment planned, and if so, when, or if not, what are we waiting on? Something like that. I think it's reasonable to ask for a little detail there. And so what I hear from opposing counsel is, one, an admission to the violation of the court's order, and two, this long-standing animosity that's really getting in the way of communication. And so I would just go a little bit further and encourage the parties to actually communicate for the welfare of the child, rather than just give a simple no to make her go away so she can't file a motion against you. That's a little scary to me. I'd like to see a little more good faith, responsive behavior. I think that should be encouraged. But I think beyond that, I think we all understand the facts and are on the same page. And so moving to the other issue, if this court is satisfied with that issue, we're on the Hawaii. We're on to the Hawaii issue, and I just want to clarify this issue. This is not a matter of the defendant mother looking for plaintiff father's opinion about whether Hawaii is a good endeavor so much. Certainly, there's some discussion about how Hawaii is good for the child, because we're talking about the child and what's best for the child, and that's the heart of the issue here. But the issue is, we just need 2 overnights. If this were a situation where the defendant mother had a stretch of time where she could take the child to Hawaii without stepping on the father's overnights, she wouldn't need to ask for permission. Hawaii is within the Hague Convention. There's no prohibition in this court's order that would prevent her from taking her child on vacation. And so we just want 2 overnights. And the plaintiff father's response didn't indicate any sort of scheduling conflict or anything like that. He just doesn't want her to go. And that's consistent with the animosity I'm seeing from his response concerning the no communication, where, I guess I'll just say no to make her go away. I don't want her to go to Hawaii. I don't think she's capable of doing anything. Well, these these complaints have already been litigated. I've familiarized myself with this court's file, and this court has affirmatively decided not to put any restrictions on my client's parenting time. And so the issue of going to Hawaii is not the issue. The issue is, can the father be flexible enough to swap 2 overnights? Let's give him some makeup parenting time, switch over a couple overnights, and let the child go on the trip of a lifetime.
Mr. Shirley.
Your Honor, my client is quite concerned with this request. Let's be clear. The defendant is, from what I understand, blind and disabled. She wants to take a 4-year-old child 3,000 miles to the middle of the Pacific Ocean with no disclosure of any details of what, who is she going to be staying with? How is the child going to be transported? There are a lot of details that just haven't been disclosed. Now, he's the sole legal and sole physical custodian of this child. As the legal custodian, he's charged with making the important decisions regarding the child's health and welfare. And I believe that this Hawaii trip, given the fact that the child's only 4, given the fact that she's blind and disabled, he's making a decision pursuant to his authority as the legal custodian of the child, whether or not this is an appropriate endeavor for the defendant to be undertaking. He has serious concerns about it. He does not agree with it. He thinks it's a terrible idea. If something were to happen, he's not able to go out there and make any kind of rescue attempt. It's just a bad idea all the way around. Considering her lack of ability to pay child support, her lack of payment of court-ordered attorney fees, financially, I don't know what the considerations are there, but it seems like this is just not a good idea for this child at this point. So that's where we stand. Thank you.
May I
Right, thank
respond,
you.
Your Honor?
Very briefly.
Very briefly, I just want to point out a few things. I think we have it wrong in law. In fact, the details were laid out in defendant mother's motion. She's staying with a friend who is named in the motion. And so saying there are no details, that's simply not true. And as a matter of law, no, I'm sorry, legal custody doesn't prohibit her from taking the child on vacation. Nothing in the order does. The plaintiff already attempted to file motions limiting parenting time as such, and they failed. This court has already decided those issues. I don't want to rehash old issues or throw mud at all. I think this is simple. We swap the 2 days and let the kid go to Hawaii.
All right. Well, I think it really is a simple issue here. And the court ordered parenting time for both parents. There's a schedule in place. Unfortunately, when we have a situation like this where the parties cannot really agree on the color of the sky, what the court does is enforce the order as written. So I'm going to deny the request to go to Hawaii, and I'm not getting into any of the arguments about why it may be good or bad for the child. I'm just going to deny the request because the parenting time schedule is not such that can happen without Mr. Greenway swapping, and he's decided he doesn't want to swap. I will caution the parties and Mr. Greenway that when and if the shoe is on the other foot, the court will make the same decision. So either the two of you are going to learn how to cooperate so that each of you can take extended parenting time and provide this child with enriching experiences, or we're going to stick to the schedule 100% no matter what. All right. Is there anything further?
Yes, Your Honor. So then I would request that I be permitted to submit an order under the 7-day rule memorializing the 2 agreements concerning the exchange and the adjustment. I'll include this court's ruling concerning the denial of the parenting time swap. And I would further ask that this court offset attorney fees regarding the admitted violations of this court's order. I think it's only fair that both parties be equally sanctioned.
Mr. Shirley, on the offset of the attorney fees issue.
Oh, Your Honor, there has been no formal effort outside of this motion to enforce my family wizard. I think that when we're required to respond to such a elaborate recitation of history. The purpose of that was solely to churn legal fees for Mr. Greenway. I believe that we've resolved the matter. The court has given a shot across the bow to Mr. Greenway to let him know that, that this is not appropriate, the non-response. And I think he can make assurances to the court that he will make an effort going forward to make direct responses, if not elaborate responses, as opposed to no responses. And the matter's been resolved.
We have admitted and unapologetic violations, and I think
Right.
there needs to be a sanction.
All right. Given that we do have an admission and a clear violation of the court's order, I will assess a $250 fine against Mr. Greenway. And yes, it seems appropriate to offset that against any attorney's fees that were previously ordered for Ms. Lubin to pay.
I will draft an order and submit it under the 7-day rule.
All right.
Thank you.
Thank you.
Thank you, Your Honor. Thank you, counsel.
We're adjourned.